Welcome to our presentation on Bill C-2, also known as the Strong Borders Act and its impact on Canada's immigration and refugee system. This session is presented by Moving Life Immigration Solutions Incorporated. I am Mirza Asma Azim, your legal counsel and consultant. Please don't forget to like, subscribe, and follow our channel for more informative content on Canadian immigration and policy updates. Bill C-2 was introduced in June 2025 in response to increasing asylum claims and concerns about border security. Today, we'll explore what the bill proposes, why it was introduced, and how it will affect the Immigration, Refugees and Citizenship Canada (IRCC) and the Immigration and Refugee Board (IRB). Our goal is to help you understand these changes and their implications for newcomers and professionals in the field. Bill C-2 was presented in Parliament and had its first reading on June 3, 2025. For a bill to become law, it must pass 3 readings in both the House of Commons and the Senate before receiving royal assent. For the latest updates on the bill's progress, implementation details, and available recourse, please check the official government website at canada.ca. The bill's primary purposes are enhancing border security with advanced technologies and protocols, addressing the surge in asylum claims by streamlining processes, combating organized crime by targeting criminal networks, and expanding government powers over immigration to give authorities new tools for enforcement and policy management. Bill C-2 introduces several major changes. Asylum claims must now be filed within 1 year of entry into Canada, emphasizing timely applications. Individuals crossing borders irregularly become ineligible for asylum after 14 days, regulating border procedures. These rules apply retroactively for consistency. The pre-removal risk assessment is available as an alternative for those facing removal, but it is a more limited protection route. The IRCC now has broader authority, including number 1, the power to cancel, suspend, or modify immigration documents, 2, the ability to pause or cancel the processing of applications to ensure alignment with new policies, and lastly, enhanced information sharing with federal and provincial partners for better coordination and decision-making in immigration matters. Bill C-2 aims to streamline the system by unifying and digitizing the asylum application process, ensuring claims are only decided while the claimant is present in Canada, allowing inactive cases to be removed from the IRB system to reduce backlog, and issuing immediate removal orders for withdrawn claims to support system integrity. To ensure fairness, the bill assigns representatives to minors and vulnerable individuals during IRCC and CBSA proceedings. This support helps these groups navigate complex procedures and guarantees a fair process, upholding the principle of equity in immigration law. The Immigration and Refugee Board will see reduced access to hearings for many claimants, impacting claimants and their representatives' ability to present cases before the tribunal. A focus on processing active and eligible cases, and a likely increase in legal challenges and judicial reviews as claimants seek to address perceived inequities in the new process. The IRCC will need to make operational adjustments to implement these new rules. The changes align Canadian asylum policies more closely with U.S. practices and grant the IRCC greater discretion to tailor immigration policy and manage cases more effectively. Bill C-2 will significantly restrict access to refugee protection. Many individuals, especially irregular border crossers and late filers, will be ineligible for IRB review. There is an increased risk of deportation without a hearing, raising concerns about fairness. Human rights organizations have warned that these changes may not comply with international law and could undermine Canada's obligations to protect vulnerable people. Human rights groups warn that Bill C-2 reduces access to protection for vulnerable individuals and may not comply with international refugee law. there is a risk that those most in need of safety could be denied protection, with serious implications for their well-being and Canada's global reputation. In summary, Bill C-2 represents a major shift in Canadian immigration and asylum policy. It introduces stricter eligibility requirements and expands government powers, sparking debate about balancing security with human rights. For more information, updates, and recourse options, please visit canada.ca. Thank you for joining me, Mirza Asma Azim, and Moving Life Immigration Solutions. Please subscribe and follow our channel to stay connected for more.